Unit 5, Liberty and Justice for All. Chapter 13, Constitutional Freedoms, Section 1, Constitutional Rights. Okay, what does the Bill of Rights do for us? Our learning objective is to discuss constitutional rights and the importance of the nationalization of the Bill of Rights. The Constitution guarantees the basic rights of United States citizens in the Bill of Rights. Today, the Bill of Rights protects the rights of individuals not only from the actions of the federal government, but also from the actions of state and local governments. The Bill of Rights was intended to protect against the actions of the federal government. A process called incorporation extended the Bill of Rights to all levels of government. The 14th Amendment, added in 1868, paved the way for a major expansion of the individual rights by the Due Process Clause, which the Supreme Court rulings have interpreted as applying to all levels of government. The Supreme Court's interpretation of the 14th Amendment nationalized the Bill of Rights, thus giving citizens in every part of the United States the same basic rights. The incorporation of the Bill of Rights has meant that in practice, citizens who believe state and local governments have denied them their constitutional rights can take their cases to federal courts, including the Supreme Court. Okay, so now the independent practice is to discuss constitutional rights and the importance of the nationalization of the Bill of Rights in a paragraph. Freedom of religion, Section 2. Can the President declare an official church of the United States of America? Why or why not? Our learning objective for this section is to explain the establishment and the free exercise clauses that define the First Amendment's guarantee of religious freedom. The Establishment Clause. This clause forbids Congress from passing legislation to establish a single religion for the United States. The First Amendment's guarantee of the free exercise of religion forbids Congress from passing laws limiting the practice of religion. In practice, religion is important to public life in the United States, and defining separation between church and state has been difficult. The Establishment Clause cases often involve religion and education. Since the Everson ruling of 1947, the court has ruled some forms of state aid to parochial or religious-based schools constitutional, but has rejected others. The court has ruled state aid to parochial schools constitutional if the aid has a clear, non-religious purpose, if its main effect is neither to advance nor inhibit religion, and if it avoids excessive government entanglement with religion. The court has allowed release time for religious instruction during the school day if the instruction is provided away from public schools. The court has struck down organized school prayers, but has allowed student religious groups to hold meetings in public schools. Debate on the court's rulings involving religion has been heated and sharply divided. The court has also ruled that states cannot ban the teaching of evolution in public schools or require the teaching of creationism. Other interpretations of the Establishment Clause have involved Christmas nativity displays in public places and prayers at government meetings. The Free Exercise Clause. The Supreme Court makes an important distinction between religious belief and practice. Religious freedom cannot justify behavior or practices that violate laws protecting the health, safety, or morals of the community. Amish parents could not be forced to send their children to public school beyond 8th grade. Children of Jehovah's Witnesses could not be required to salute the flag in the classroom. in a paragraph or less, explain whether the Establishment Clause, the Free Exercise Clause, or both are involved in one of the examples below. A. Can a nativity scene be displayed in a public park? Or B. Can a student wear the traditional Islamic head covering to school? Section 3, Freedom of Speech. A recent video that portrayed the Prophet Muhammad in a negative light was created by a man living in the United States. This resulted in an angry anti-American protest in Islamic nations. Can our government prevent such videos from being produced? Why or why not? Our learning objectives for this section explain the limitations on free speech, explain how the First Amendment protects diversity of opinion in the United States. Types of speech. Free speech includes verbal expression of thought and opinion, and symbolic speech, using actions and symbols. Because symbolic speech involves action, it may be limited by government restrictions that do not apply to free speech. Government can regulate or forbid symbolic speech if it falls within the constitutional power of government. If it is narrowly drawn to further a government interest not related to suppressing speech, or if it leaves open enough other channels of communication. The rights of free speech must be balanced against the need to protect society. Free speech may be limited when it clearly presents an immediate danger, as in the Shinnick case in 1919. Free speech can be restricted even if it only tends to lead to illegal action. That's known as the bad tendency doctrine, given society's need to maintain public order. The court has ruled that the First Amendment freedoms have a preferred position because they are more fundamental than other freedoms. Laws limiting them are presumed unconstitutional. The court has held that people are free to speak out in support of political objectives. However, free speech does not protect those who advocate immediate and specific acts of violence. Other speech not protected. The First Amendment does not protect defamatory speech. Defamatory speech includes slander, or spoken words, and libel, written words, in false and damaging statements about someone. Public officials and public figures in general are excluded from the right to sue for slander in order to preserve an individual's right to criticize the government. Fighting words or speech intended to provoke violence are not protected. School authorities can regulate students' free speech at school events and during activities. Independent practice. Explain the limitations on free speech and explain how the First Amendment protects diversity of opinion in the United States in a paragraph. Section 4, Freedom of the Press. The news media spends a lot of time covering high-profile criminal cases. Critics argue that this coverage makes it hard for the accused to receive a fair trial. Should there be restrictions placed on the media to avoid contaminating the potential jury pool? Why or why not? Our learning objectives for this section. Analyze First Amendment protections for the sharing of information and opinions. Prior restraint forbidden. Prior restraint, or censorship in advance, is permissible only in cases directly related to national security. In Neer v. Minnesota, 1931, the court ruled that states could not stop the publication of a newspaper because that action involved prior restraint. In the Pentagon Papers case in 1971, the majority ruled that the government could not stop the publication of secret government documents because it would involve prior restraint. Fair trials and free press. The First Amendment rights of a free press sometimes conflict with the Sixth Amendment's guarantee of a fair trial. After the Shepard case, 1966, the Supreme Court described measures that courts might take to restrain press coverage, including moving the trial site, limiting the number of reporters in the courtroom, controlling the reporters' conduct in court, keeping witnesses and jurors isolated from the press, and sequestering the jury. Gag orders barring the press from publishing certain types of information are illegal and are allowed only in unusual circumstances. After the court ruled that reporters, like all citizens, must testify in cases if called and cannot refuse to reveal their sources of information, some states passed shield laws to protect the media from being forced to disclose confidential information in state courts. The founders viewed the press strictly as printed material. Electronic media had not yet been invented. Radio and television do not enjoy as much freedom as other press media because they use public airways. The Federal Communications Commission, or FCC, regulates radio and television. That agency cannot censor broadcasts, but it may set standards. Movies and the Internet are protected by free press guarantees. Communities may regulate obscenity within limits acceptable to the courts. Advertising is commercial speech and thus receives less protection than purely political speech. Independent practice. Analyze First Amendment protections for sharing of information and opinions in a paragraph. Section 5. Freedom of assembly. Now, obviously, you're not going to be able to see the YouTube clip here, but there is a YouTube clip here that shows protesters that are part of the Occupy Wall Street movement. And so the question is, what are these protesters exercising in the video? Or what rights are they exercising? And the truth is, they're exercising a couple of rights, both out of the First Amendment. One would be the right to free speech, and the other is the right of assembly. So our learning objectives are to explain the freedoms and restrictions placed by the First Amendment upon gatherings of people. Protecting freedom of assembly. Freedom of assembly is a right closely related to freedom of speech. The Supreme Court in Dijon versus Oregon, 1937, ruled that free assembly is important as free press and free speech, and that free assembly is protected from state and local governments. Freedom of assembly includes the right to parade and hold demonstrations in public places, but those who organize the events must get a permit. Demonstrations at public facilities may be limited. Demonstrations are not allowed on private property, such as shopping malls and abortion clinics, because they interfere with property rights. When people assemble to advocate unpopular causes, police may have difficulty protecting them from violence and disorder. The Nazi Party march in Skokie, Illinois in 1977 illustrated the heckler's veto, where the public vetoes the rights of free speech and assembly of an unpopular group. Police may disperse a demonstration in order to keep the peace, but in the Gregory case of 1969, the court upheld the right of assembly by persons peacefully demonstrating in support of an unpopular cause. Protection for labor picketing. Labor picketing is different from other demonstrations. It seeks to persuade customers not to deal with a business whose workers are on strike. Before 1940, the Supreme Court supported restraints on labor picketing, but in that year it ruled that picketing was a form of free speech. In the years since, forms of picketing have been limited in several key rulings. Freedom of association. The right of a free assembly includes the right of free association, including joining a political party or interest group or other organization. Membership in groups advocating the use of force to overthrow the government, the court has ruled, is not illegal. When members of such groups actually prepare to use such force, however, the acts are punishable. Independent practice. Explain the freedoms and restrictions placed by the First Amendment upon gatherings of people in a paragraph. Chapter 14, Citizenship and Equal Justice. Section 1, A Nation of Immigrants. We are said to be a nation of immigrants. What is an immigrant? Our learning objectives are to describe immigration policy and explain how it has changed. Immigrants and aliens. Immigrants come to a new country intending to live there permanently. Aliens live in a country where they are not citizens. The federal government classifies aliens into 5 categories. Resident aliens, those are ones that establish a more or less permanent residency. Non-resident aliens that are here temporarily. Enemy aliens, those are aliens that come from a country with which we are at war or have very tense relations. Refugees, and illegal aliens. Protections of the Bill of Rights, such as the freedom of speech and assembly, apply to aliens as well as citizens. Aliens cannot vote. Most are exempt from military duty and serving on juries. In 1882, Congress began to fully use its power to regulate immigration, and it imposed many restrictions during the next 4 decades. The Immigration Act of 1924 sharply lowered the number of immigrants who could arrive each year and favored those who came from Northern and Western Europe. The Immigration Reform Act of 1965 changed the immigration policy by fixing a ceiling on the countries in the Eastern Hemisphere and a different ceiling on those in the Western Hemisphere, as well as creating a complicated system for preferential treatment of selected immigrants. The Immigration Reform and Control Act of 1986 was passed to stem the tide of illegal immigrants to and allow illegal immigrants to become permanent residents and citizens. The Immigration Act of 1990 was passed to revise the 1965 immigration law, putting limits on the flood of immigrants from Asia and Latin America, and to open immigration to Europeans who had been adversely affected by the 1965 law. The 1990 immigration law reduced the total annual immigration slightly, encouraged immigrants with special skills, and set up special categories for special immigrants like close relatives of United States citizens. Independent practice. Describe immigration policy and explain how it has changed in a paragraph. Section 2, the basis of citizenship. What is the difference between citizens and resident aliens? Our learning objectives are to explain the requirements for United States citizenship. National citizenship. Citizens of the United States have rights, responsibilities, and duties. The founders assumed that states would decide who was a citizen. Citizenship came to have both a national and state dimension. The Dred Scott 1857 ruling that African Americans were not U.S. citizens led to the adoption of the 14th Amendment, which defined citizenship at both the state and national levels. Citizenship by birth. Citizens by the law of the soil are born in the United States or its territories. Children born to a parent who is a U.S. citizen are also citizens by the law of the blood, including children born in another country of American parents. Citizenship by naturalization. Naturalized citizens have most of the rights and privileges of native-born citizens. Congress has established qualifications for naturalization. Applicants must be of good moral character and have entered the U.S. legally. Applicants must read, write, and speak English. Applicants must show good basic knowledge of American history and government and support the principles of American government. Steps to citizenship. An applicant must file a petition requesting citizenship, be at least 18 years old, and have been lawfully admitted resident alien, been a lawfully admitted resident alien for 30 months out of the previous 5 years, and have resided in the state for at least 3 months. At a final hearing, a judge administers the oath of allegiance to new citizens. Losing citizenship. Only the federal government can take away citizenship. A person may lose citizenship voluntarily or involuntarily. The responsibilities of citizens. Responsible citizens need to know about the laws that govern society. Responsible citizens participate in political life. Independent practice. Explain the requirements for the United States citizenship. Section 3, the rights of the accused. If you're accused of a crime, what are you presumed innocent, or you are presumed innocent until what? Okay, learning objectives. Summarize the rights of Americans accused of crimes. Searches and seizures. The Constitution and the Bill of Rights protect the citizens of protect the rights of accused persons. The Fourth Amendment offers protection from unreasonable searches and seizures, but the courts have dealt with this on a case-by-case basis. Today, most police searches are conducted with a court warrant. The 1914 exclusionary rule restricts the use of illegally obtained evidence. Supreme Court rulings in 1985 and 1987 limited the warrant requirement for legally stopped cars and students and their property in school. In 1967, the Supreme Court reversed an earlier ruling permitting wiretapping. In 1968, Congress passed a statute requiring a court order before using wiretapping to obtain evidence. The guarantee of counsel. The Sixth Amendment guarantees the defendant the right to an attorney. In federal cases, courts generally provide an attorney for defendants who cannot afford one. State courts must also provide attorneys for defendants. Self-incrimination. The Fifth Amendment protects witnesses before grand juries and congressional investigating committees. The Fifth Amendment also protects defendants against forced confessions. The Escobedo 1964 and Miranda 1966 decisions expanded the protections of persons arrested as suspects in a criminal case. Double jeopardy. The Fifth Amendment protects accused persons from double jeopardy, or being tried twice for the same crime. A person may be tried more than once for the same act, however, when a crime violates both a federal and a state law. It is not double jeopardy if a single act involves more than one crime. A defendant may be tried for each offense. In case of a hung jury, a second trial is not double jeopardy. Cruel and unusual punishment. The Eighth Amendment forbids cruel and unusual punishment. The use of the death penalty is an ongoing controversy under this amendment. Independent practice. Summarize the rights of Americans accused of crimes. Section 4. Equal protection of the law. Can people be denied the right to vote based on race? Learning objectives. Explain the concept of equal protection and the test by which the Supreme Court determines discrimination. Meaning of equal protection. Both the 14th Amendment and the 5th Amendment require that all people are entitled to equal rights and equal protection of the law. The Supreme Court has developed guidelines for deciding when state laws may violate the Equal Protection Clause. According to the rational basis test, the court will uphold state laws that distinguish among different groups of people if the state shows good reason for those classifications. Classifications in state laws based on race or national origin are a suspect classification. The state must show some compelling public interest to justify them. State laws that violate fundamental rights, such as the right to vote and the First Amendment rights, are unconstitutional. Proving intent to discriminate. Discriminatory laws classify people solely because of their race, gender, ethnic group, age, physical disability, or religion. To prove a state or local government guilty of discrimination, one must prove the state's intent to discriminate. The struggle for equal rights. For nearly a century after the 14th Amendment was adopted, the courts upheld discrimination and segregation against African Americans. In Plessy v. Ferguson, 1896, the Supreme Court used the separate but equal doctrine to justify segregation in the United States. In Brown v. the Board of Education, 1954, the court overruled the separate but equal doctrine and touched off a long struggle to desegregate public schools. Civil rights workers peacefully broke laws supporting racial segregation. Protesters who were arrested and convicted then appealed, challenging the constitutionality of these laws in the courts. Influenced by the civil rights movement, led by Martin Luther King Jr., Congress passed major civil rights legislation to ensure voting rights and equal job opportunities, such as the Civil Rights Act of 1964. Independent practice. Explain the concept of equal protection and the test by which the Supreme Court determines discrimination in a short essay. Section 5. Challenges for Civil Liberties. Our learning objectives are to contrast trends and laws intended to ensure equal opportunity, privacy, and a citizen's right to know. Affirmative action. In the 1960s, the government began programs that gave a preference to minorities, women, or the physically challenged in hiring and promotions, government contracts, admission to schools and training programs, and in other areas. Most affirmative action programs are required by federal government regulations or court decisions. Others are voluntary efforts. One of the most important applications of affirmative action is in higher education. In Bakke, 1978, and other cases, the Supreme Court has held that although a strict quota system is unconstitutional, a state university can consider race along with other factors when admitting students. Outside of higher education, the constitutional status of affirmative action is unclear. The court has struck down as many programs as it is upheld. Discrimination against women. New challenges against discrimination toward women have been raised. The Supreme Court held that past laws discriminating against women did not violate the Equal Protection Clause. In its ruling in Reed 1971, however, the court held a state law was unconstitutional because it discriminated against women. Since the Reed case, the court has allowed some laws based on gender classification, but has declared others unconstitutional. Congress has passed many laws protecting women from discrimination. Citizens' right to know. The 1966 Freedom of Information Act requires federal agencies to grant people access to public records upon request, with some security exceptions. The Sunshine Act of 1976 requires federal agencies, boards, and commissions to hold meetings open to the public or provide a complete record of the meeting. Citizens' right to privacy. The Constitution does not specifically mention privacy, But the Supreme Court ruled in Griswold v. Connecticut, 1965, that personal privacy is one of the rights protected by the Constitution. Widespread use of the Internet challenges the right to privacy because of such issues as online surveillance by the government and the availability of personal information on websites to hackers. War and other national emergencies create tension between the need to maintain individual rights and the need to protect national security. The U.S. Patriot Act, passed in response to the September 11, 2001 terrorist attacks, greatly increased the federal government's power to detain, investigate, and prosecute people suspected of terrorism. Questions continue to arise over whether the act poses a threat to civil liberties. Independent practice contrasts the trends and laws intended to ensure equal opportunity, privacy, and a citizen's right to know.